My lady, can I just try and give you a as definitive an answer to the question you posed me just before the short adjournment, which is, what do we know about?
Sorry, let me just. It's all right. That's fine. Thank you.
Yeah.
Reviews or resumed hearings.
Yes.
And so, for these purposes, those terms are synonymous. Aside from section 27C of the Act, this part of the Act doesn't address resumed hearings. So apart from dealing with the powers that can be exercised as resumed hearing, it doesn't deal with resumed hearings. The rules, and that's, so in the authorities bundle at page 32, maybe just for my lady's note, there is a definition of resumed hearing, which is that resumed hearing means a hearing for the purposes of reviewing directions given.
Just another moment.
32.
Sorry.
Page
32.
Yep, found that. Yeah.
Right at the bottom, just above notes.
Yes.
So a hearing for the purpose of reviewing directions given orders made by a practice committee, at which a practice committee is considered whether to give a direction under section 27C, which is the relevant section for our purposes. Then at 52 in the same bundle, starting at the foot of the page, but substantively at the top of the next page, 53, are the provisions relevant to a resumed hearing. So 1, notification, 2, order of proceedings, 3, decision, and then notification, etc. But it doesn't tell you how you get effectively to the stage before Rule 28, if I can put it like that. And then finally on this, in terms of the guidance, and this is not, I'm afraid, an exhaustive list, but just an illustrative. So this is the supplemental bundle. There doesn't appear to me to be anything in the guidance as to how the PCC should conduct a resumed hearing. But what it does tell the PCC is, firstly, at page 48, paragraph 6.15, in relation to conditional registration, that it must decide whether conditions will be reviewed at a specified time.
Did you say page 48?
Page 48 of supplemental.
I've got the 2000. I'm sure it's my fault. I've got the 2016 guidance. Yeah.
Yes.
Oh,
Page 48 of that.
of that. You mean the internal numbering?
No.
No.
I haven't got it. I've only got
Paragraph
one number.
17.
I haven't got, so that's odd.
Is a paragraph number easier?
I'm there now. Thank you very much. It's
6.15.
Yep.
Is talking about it in relation to conditions. And then, more relevant to us, 6.23 over the page, must decide whether suspension will be lifted automatically at the end of its term or whether it will be subject to a review hearing.
So this has no statutory basis. This is, does it, or?
No, save I would anticipate that there's I need to come back as to whether there is a statutory power to devise rules.
Yeah.
Or something in fact, or in the statutory instrument.
Well, it says it's been developed by the GDC for use by fitness to practice panels.
Yes. But that information, I don't think, in the introduction on 34 and 35 doesn't explain the origin aside from that.
Yep.
So I was going to just move on and just, I have 3 or 4 further points. Firstly, just in terms of the conclusion by Mr. Justice Ritchie, that the effect of his conclusion, this is essentially what he is saying, is that it achieves these objectives at least, not breaching the statutory maximum. It achieves consistency with the substantive direction made by the practice committee, the PCC, and he would, in his analysis, the carefully titrated point he made. And thirdly, it's consistent with the statutory purpose of regulating the profession in such a way as to meet the overriding objective. And the overriding objective, the overriding objective is the public interest, and then it's subdefined in the early parts of the Act. Secondly, just 2 further points on anomalies. I've touched on them already. Firstly, Mr. Aga's case is an illustration of how a single suspension can operate and the effects of Section 27C be maintained, because each of the reviews he underwent was considering whether to exercise the Section 27C power. Secondly, there is no practical difference between an order for immediate suspension or a direction for suspension, or to use another term, a substantive suspension. Whether from the perspective of the registrant or, equally importantly, the perspective of the public. The public is not going to be concerned whether a registrant is suspended by virtue of one piece of paper or another piece of paper. The public will be concerned that proportionate action has been taken.
Mr. Hare says there is a difference between the two because the public will look at the register, and if it's a direction for substantive suspension, they will know that that follows a substantive review of the position by the PCC, and that if it's an order for immediate suspension, they will understand that it's just pro tem while you think about whether you're going to appeal or not. So the public a very careful member of the public may calibrate those 2 sorts of suspension differently.
But that equally careful member of the public will understand that the immediate order could not have been made without there being a substantive order. Then, just to deal very shortly with paragraphs 31 and to 33 of my learned friend's skeleton argument, so the purpose of fitness to practice sanctions. And essentially his point is that the judge's conclusion undermines one of the aims of the sanction, namely giving the registrant an opportunity to remediate, that, with respect, is more illusory than real. And in the example that he gives, if the registrant elects not to remediate, then at a review hearing, he cannot and should not be surprised if his suspension is extended. And what happened to Mr Aga on his first review is illustrative of precisely that point. And what the committee said to him was, you've started this too late. And that we are therefore not satisfied that you have proper insight into the deficiencies that we found. And so it leaves in the hands of the registrant the decision whether or not to take action necessary to secure the optimal outcome at a review hearing. And that's where the responsibility should lie. And then finally, just in relation to fairness, so this is paragraph 34, and I've touched on this already, so I'll be very brief, because I've dealt with impact and the effect of the consultation exercise. I would just say this, that the judge was entitled to have regard to fairness to the registrant, and in doing so he didn't give it precedence over the public interest. What he sought to achieve was effectively a level playing field, so no disadvantage to the registrant. At the same time, we would say maintaining the effect of the direction that the practice committee had made in July 2023. So that approach was consistent with the overall structure of the scheme and its operation. My ladies and my lord, those were my final points.
Thank you.
Thank you very much indeed, Mr Kennedy. Yes, Mr Hare.
Unless there's anything I can assist with, I didn't propose to make any points in reply.
No, thank you very much indeed. Mr Hare, Mr Kennedy, we are very grateful to you and those who've worked with you for the assistance which you've given the court. You will be unsurprised to hear we're going to reserve judgment. In the ordinary way, it will be sent to you and to those who have been specifically named for the correction of typos and no more. It will be handed down remotely, and we would be assisted by any written submissions relating to costs or any outstanding matters. And then, again, that can all be dealt with, and we can hand down a written ruling. That's it. Thank you very much indeed.
Court, right in favour.